we ended up taking a plea and for our client. And then if I remember correctly, the recommendation and kind of the global deal was a period of probation and restitution. And restitution was a gigantic amount. I mean, let's say over six figures or in the six-figure range. And it just was probation. Is there, and then I think we just got rid of a charge. I think it was just Social Security fraud and got rid of theft of government funds, something like that. He pled guilty to one charge. Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. I remember correctly, and correct me if I'm wrong, the case we did together, and I don't want to go into too much detail about it, but the case that we did together, I think from start, meaning from the day we kind of knew the person got arrested to arraignment and I think we pled guilty. We ended up advising to plead guilty, and the client wanted to. Was about 6 months. Does that seem right, or was it shorter than that, or longer than that? Do you recall?
I felt like it might have been a little bit longer because he might have done the plea within 6 months, but then there's the sentencing aspect of it, and almost 90%. Well, I think it's every time after you do a plea. So let's say you get an agreement. You say, I'm going to plead to one count of Social Security fraud, and you go in and you do the plea, and you plead guilty to it. Then what they normally do is they'll have a pre-sentence or a sentencing memorandum that's done by an independent sentencing section of the government.
And that's a big interview with the client themselves, correct? If I remember.
Client, family members, anything like that, any victims in the case. And so they'll do a sentencing kind of memorandum that will detail what their sentencing recommendation is. And then it could be the same as the agreement that you might have worked out with the prosecution, because normally you'll work out some sort of resolution with the prosecution, say if they plead to this, they get 2 years of probation and 18 months in prison, right? That's your agreement. But it doesn't negate the fact that there still be an independent sentencing memorandum that will be done. And that recommendation may come back and say, we think they should get 9 months, or they may say, we think they should get 2 years, right? It's independent. And so you have that. So what ultimately you would do is you'd have that sentencing, and that normally takes 60 to 90 days because of the process and the amount of things that they have to do to interview or whatever it is. And then you get a copy of it, and the prosecution gets a copy of it. You get to review it and say, oh, no, you interviewed Mr. Jones, and Mr. Jones said he was his cousin. It's not. It's his neighbor, right? Any things that you can find in there that are faulty, or maybe they calculated on the sentencing guidelines incorrectly, that there was a different prior criminal history or whatever it is. You get to review it, submit any revisions you want, and then they go back and they give you a final. And so you have a final sentencing memorandum that's submitted to the federal court judge, who has all the power to do whatever they want.
Right. So even if you worked out a deal with the prosecutor, the judge doesn't have to follow that.
And it happens all the time. I mean, I constantly rely on the federal judges to get a better deal because, especially in the drug cases, a lot of the federal drug cases, because there's mandatory minimums on federal drug cases, and, trying to get outside of that mandatory minimum, because if you're carrying around some certain amount of drugs and the weight it's a certain weight, you get 10 years. And so you try to rely on the federal judge to make an exception to give them 6 years or 5 years or 4 years or whatever it is. Because the federal prosecutor, a lot of times they'll take a harder stance on certain stuff.
Sure.
So, but it's up to the judge.
That reminds me of something I wanted to address earlier. You talked about when you go to trial, it's kind of you and your client on one table, and on the other table, it's, the prosecuting attorney and, a slew of folks working for that person. And it's so often, especially in the federal government, where you see programs that are underfunded and understaffed. But man, when you get to trial, you see the full force of the government that doesn't want to lose a trial, right? And so now we'll fund that and we'll get everyone involved to go to trial because we don't want egg on our face to lose these cases, because we got to send a message to everyone else to not do, like you said, we're sending a message. And I always find that interesting that we can't afford to fund certain programs within Social Security just to make, right now, I don't know if you know this, but the typical wait time for someone to get from application to a Social Security judge right now is about 3 years, 2.5 to 3 years. And the reason we're getting is Social Security is understaffed and underfunded. Okay. But to your point, depends on what they want to fund, right?
Well, that's money going out. You have to remember Social Security is money going out. So why would
coming in too, from workers,
well, they're always getting the Social Security coming in, but on Social Security benefits, it's money going out. Why would they want to keep that going any faster?
Yeah.
Let's make the process really fast so we can get more.
But because people, and my argument is because you got this really truly disabled people who need it, and we can talk about there might be people committing fraud and whatnot. But I genuinely have someone who's represented thousands and thousands of disabled people. I'm meeting people that died during the process. And I'm just like, dude, I'm sorry that this is happening and it's so slow. I genuinely am. I wish I could make it faster.
Well, I think also I have an undergraduate degree in finance. And one of the things you learned early on is that it's, corporations, machines, governments, there is no real conscience there. You think that there's a conscience there, and there's not. It's about profits. It's about budgets. It's about balancing out dollars and what's coming in and what's going out. Yeah, there are people along the way, but overall, the agencies itself and those types of things are all about making money and not losing money and doing those things. And so, I think people get wrapped up in it, in that you think, well, why aren't I'm obviously disabled. I obviously should be receiving this benefit. I've got all of this information, and it's going to take another 2 years to get it in front of somebody that can actually say yes. It's got to be incredibly frustrating.
Yeah.
For those people that are in those situations. And so, going back to that federal thing, is that when the benefits is that in my world, in the criminal defense world, the feds never take a case that they can't win.
Right.
They never take a case that is questionable. They have a lot of evidence against you if it gets to the federal court.
Right.
Because those federal prosecutors, they're kept track of, their wins, their losses. Those things are kept in check, and they always want to win. When I was a prosecutor in circuit court, a lot of times you'd have cases that you might refer to the feds. So you're like, hey, this could be a federal case based on maybe there were guns involved, or the amount of drugs, or it crossed state lines, or did something along those lines that brought it to a federal jurisdiction. But those federal prosecutors would not take those cases unless they were lock solid. We caught them in the act. And there's a video. Yeah, they have to be slam dunk cases, or they will not take them. And so, that's, you have to be prepared for that as well, is that if it gets to the federal case. And one thing I wanted to mention too, just as a side note, is when we were talking about the referrals, a relative or whatever, a lot of people will come in and say, hey, Bob down the street's doing the same thing that I'm doing.
Yeah.
Right. And he's been getting away with it for years. Right. Well, Bob down the street may not have a relative or ex-husband or ex-wife that is out for him, right? So, and has now reported it, and they don't care. So just because someone else might be doing something that's an omission or a false statement or a misrepresentation doesn't mean that you're going to get away with it. So
Right. So let me ask you a little bit about sentencing. So obviously when you go to trial, there's a couple different options that can happen. You can do in Fed court. I'm assuming you can do bench trials and jury trials, correct?
Yep.
So you have that option, and you can either be found not guilty or guilty. Not guilty, you just basically get to walk out, and guilty, then we go into sentencing.
Yeah,
a plea, you kind of, how often, and before we move away from pleas, and you talked about the sentencing recommendation from the independent source, how often are judges at the federal level following that recommendation versus the recommendation of the deal that you and the prosecuting attorney made?
Well, I mean, a lot of times it depends on the crime. It depends on the criminal history. It may depend on victims, how many victims there might be on a case. But, the sentencing memorandums normally are in line with what the judge normally does to a certain degree. You have, as a defense attorney, you have ways to get, if it's more, right, then you have a way to try to get it down. And this is the agreement we did, and this is the reason we pled, because we were relying on the federal judge to follow that recommendation. But he still has to make a basis for it. He has to give a reason for it, right? He can't just say, well, because of the agreement of the parties, I'm doing this.
Right.
He has to, kind of detail it a little bit on why he's following it. But normally those sentencing memorandums are helpful. They help your case. They don't normally make it worse. And the only time it really becomes an issue is if you have repeat criminal defenders. And so there can be a repeat criminal defender statute that says if you have these certain amount of priors, then it bumps it up. Right. And sometimes you have to challenge prior convictions. And sometimes the sentencing memorandum doesn't go into as much detail as it should about those things. But normally it helps out. Or is in line with the recommendation.
Right. So in our case, and correct me if my memory is wrong, but in our case, we ended up taking a plea and for our client. And then if I remember correctly, the recommendation and kind of the global deal was a period of probation and restitution. And restitution was a gigantic amount. I mean, let's say over six figures or in the six-figure range. It just was probation. And then I think we just got rid of a charge. I think it was just Social Security fraud and got rid of theft of government funds, something like that. He pled guilty to one charge. Generally speaking, did you get a chance to look at the sentencing guidelines, or for someone who's never, and I know that there's criminal background that goes into all of this, but for that charge, if there's no criminal background, is it generally probation, or do people generally go to prison? Do you recall, or did you get a chance to look at it?
Well, I mean, in those types of cases where, you have no prior criminal history, the likelihood of probation is very high on something like that. I mean, it's, you're accepting responsibility for the crime in itself by taking a plea, right? Number one. Restitution, that was a lot of times overlooked, is restitution. If you have the resources to be able to pay back what you took, that's huge. So let's say you have, over 3 years or whatever it is, it's $35,000, right? And you have the resources that you can say, hey, he'll plead to this and he'll pay 15 of the $35,000 back, right? Then that helps you out in the mitigation and negotiation of the case, especially in our scenarios where you have privately retained an attorney that you have some resources at least, right? And it's I always say this, it's worthwhile to hire a privately retained attorney if you can, because these are important things. These are life-changing times that, and I'm not saying you hire me, or you just hire someone that knows how to handle these types of cases, and that it's worthwhile because it can mean the difference between certain things and certain conditions and certain sentences and certain charges long term on how you handle these things. But normally it's a probationary. They give the guidelines, which are loose, the 5 to 15 years, right? A lot of times those are people that have done egregious things and have made very intentional misrepresentations, right?
Right.
A scheme where you have collected Social Security cards of deceased people and made claims over years, and you've been receiving it. It's not just one victim. It's not the person that, your wife died and, you continue to receive Social Security benefits for her because it's not been reported, right? That's normally not the scenario where you're going to go to prison on, but if you have several people, right, or scheme, then those are the things. But in most cases, if it's just the normal Joe walking down the street that made some misrepresentations, I would say you're less than 2 years in prison or probation, right?
Well, and then restitution, and then you're a convicted felon.
Yep.
You'll have a felony.
Bye-bye to the benefits, right?
Right.
Long term, right?
Yeah. So, you can be a convicted felon and collect benefits. The problem is if the restitution will come out of every Social Security check that you try to claim in the future will be used to pay that back at 100%. So let's say in that scenario, a $35,000 restitution, they're able to pay off 15, but they still owe 20. And then years go by and they're just maybe making a payment plan of a couple $100 a month out of their own pocket. But let's say then they become retirement age.
Right.
It's like 67, depending on what year you're born, 66, 67 and up, depending, right? You go to collect your retirement and you still owe, like, let's say $15,000. Every month that you're supposed to get your retirement, 100% of that check will go back to pay off that $15,000 that you owe. It's called an overpay.
Right.
And so if you're, and in that scenario, sure, I'll collect my check and then at least I'll get that paid off, and in a year or two, I'll be able to collect Social Security on my retirement. But if you're like at 100,000, 300,000, 200,000 in that range, you're basically not going to get Social Security.
Right.
So.
Well, and that's the problem is that if it gets to a federal level, they might go back 5-6 years on misrepresentations. Right. And so that's just the number of restitution just racks up, right? That they supposedly overpaid. And that's normally not one of the things that they negotiate about, oddly enough, is that if you commit the crime, like you say, hey, yeah, I did Social Security fraud, and they give you a deal to plead to one count instead of, the 7 counts that are on the indictment, right? They're not going to let you challenge the restitution. They're going to say you have to accept that you also owe us $62,000 in restitution. They're not going to let you, which is different from circuit court, right? I can challenge restitution, and the judges are very open to challenging restitution in circuit court, but not in federal court. They want you to accept that number as well as with the deal, because they know they have this big hammer in the back that they can hammer you with. So
one thing that we did, is I think the one aspect of that, just in our case, and I don't want to give away too many details, but generally in these cases, you could ask Social Security to rework the number and ask for an administrative law judge in Social Security world who is more familiar with how these kind of overpayment cases work, to kind of present that case to them. And I think that worked because in some levels, because for us, because it's like, oh, great, let's just kick the can down to someone else to let them figure it out. Right. While you're not challenging it directly with the federal court judge or the prosecutor, you're just saying, hey, look, let's have experts who do this every day, who, which is the Social Security Administration and an administrative law judge, sit down and look at all the numbers, and let's have them go through it and let us pitch the case to them. And whatever the judge comes up with there will be the restitution. And I think, if I remember correctly, and again, it's been years, but if I remember correctly, I think was accepted.
Yeah, that's a great point, Peter, is that, in those situations, a lot of times, you not only have an overpayment, you may have a fine or a fee or whatever it is that adds on to it. And those things may or may not be applicable because you didn't really understand what the repercussions were of it, right? You filled in that initial application or that form and you checked no, and it should have been yes, right? And then that compounds over years. And then it's able, in our situation, you're right, we were able to kick it down the road a little bit to allow them to really get the proper number of what restitution was owed on it, what actually was overpayment. Because if I remember, there were some deductions that were taken out and some things that were added, and it was a much more complicated process than just you owe, $50,000 because we paid you an extra $1,000 for 50 months, right?
Yeah, it was extremely complicated. There was a lot of things going on in that case. But just for our listeners' sake, and I just want to recap this one aspect. If you check the wrong box and it's unintentional, you're not going to get arrested. The issue is once you become aware of it, like, oh, I screwed this up, I owe money, then you go take care of that. Yeah, I'm going to check the right box. I'm going to go to Social Security. I think I screwed this up. I think I owe you guys money. If you're proactive about it at that administrative level right away, and they're not going to arrest you. They're going to say, oh, good job. You fixed it. Pay us back. You have an overpayment. We'll work with you, because we represent clients who get overpayments, who've informed Social Security. I started working. Social Security sent me all this money and it just auto dropped into my account, right? And I told Social Security I started working and they're still paying me. And Social Security's like, oh yeah, oops, you owe us 10 grand. And there's an actual rule within Social Security is that, and the funny thing is we talk about under-resourced, Social Security has a rule that if the overpayment is not your fault and is the fault of the Social Security Administration, meaning you did everything right, but we still paid you, you can ask for a waiver and ask us, you can't afford to pay us back. And that can be granted. In fact, I've seen it granted many times where it's done through the administrative level, it's done at the hearing level, or even sometimes before at the case management level, where like we say, hey, look, here's you guys have a letter in the file. He wrote you that he started working and you kept paying him, and he even sent a second letter. And now you say he owes you 20 grand. There's a rule that says, even though it's not your fault, you still owe it.
Right.
But if it's not your fault, you can ask for a waiver. And then a lot of times they're like, man, I can't afford to pay 20 grand back. How am I going to do that? I can barely live off my Social Security check now. And then we'll fight for a waiver for our clients. And so
that's just it, though. I mean, the amount of resources that the federal government have, they don't have the amount of resources to go after everyone. And for, these omissions or factual things that change throughout your life, right? Things happen, residencies, rent, all these kinds of things that, that you may have to happen, life challenges that come up, jobs, kids in and out, and whatever it is, that happens that affects, the Social Security benefits that you're going to receive. Yeah, just it. If you're proactive, if I would give any advice, I would say this: if you are going to, every 3 months, or 4 months, sit down and take a look at your Social Security stuff, right? It's not something that you just fill out once and say, hey, see you later. You have to be proactive about, because Social Security benefits themselves and laws might change, right? With different things. And you might be able to get more, or you might end up getting less, or things might change where you can work a little bit more, or you can work a little bit, less, or whatever it is. But I would say every 3 or 4 months, at least quarterly, right? You just sit down with the Social Security stuff that you have and the notices and the things that you have and make sure that things are correct. And if they're not correct and you forgot to tell them that you started a job, then you're proactive about it, right? Yeah. And then, then you can, no one's going to prosecute you for those things.
Yeah, that's a great tip. I would encourage you, our listeners, if you're on Social Security or pursuing Social Security disability benefits, read the stuff they send you, right?
That's right. It
says important information, typically across the top is important information or whatever. Just read it, and a lot of times it feels 3, 4, 5, 10 pages long. and if you're one of our clients and you have questions about that, that's what we're here for, is to help answer those questions. If you're not a client of ours and you're already on Social Security disability, just read it, and see what it's saying. Because a lot of times that information is there to tell you, like, hey, if things change, let us know. And, if you go back to work, especially if you go back to work, that's the big one with Social Security. If you go back to work, you should let them know. Or if you're an SSI recipient, like you said, your finances change, don't just hide it. You gotta inform Social Security, because they're telling you in those letters, if things change, you have to let us know.
Well, and the great thing about, the thing about those forms and those notices is that even as an attorney, sometimes they're confusing. It's hard to sort through some of those things because they say this, and you'll refer to this, and this section will be applied to this section, and then if that happens, then this will affect this part of your benefit. And so, even reaching out to a Social Security attorney to be able to explain those simple things so you don't get in trouble, right? Or you have someone that's managing it in some way is important, because it's, the last thing you want to do is get in trouble. And the last thing anybody wants to do is have to go through the criminal process for Social Security fraud, theft of government services, thefts, anything like that.
Right.
And so, you want to make sure you're on the right path.
So Shanon, if one of our listeners is in need of a criminal defense attorney, either in Oregon or Idaho, what's the best way they can find you?
Just email me at Shanon, SHANON, at graylaw.org, GRAYLAW.org, or graylawfirms.com.
Perfect. Well, listen, but I am so grateful for your time today. Thank you for sort of walking us through what it might look like at the criminal level of if someone's ever charged or with SSA fraud or theft of government funds or whatever else they might charge you with. And I know how busy you are. It's been a pleasure to catch up and to hear from you.
Well, I love talking to you, Peter. Thanks for having me on.